Hello and welcome to Ideas Having Sex with Chris Kaufman. I'm Chris Kaufman, and today I'm speaking with economist David D. Friedman about his book, Legal Systems Very Different from Ours. David and I talk about the legal systems of various societies throughout history and around the globe, including Imperial China, the Comanche, medieval Iceland, the Finnish Romani, and traditional Somalia, among others. We also talk about some of David's earlier books, including The Machinery of Freedom, and some current projects he's working on. This is my interview with David Friedman.
I'm an academic economist who has a doctorate in theoretical physics, an interest in recreational medievalism, and spent about close to 30 years teaching at law schools, teaching and researching at law schools. And I guess I suppose I'm in a sense an economic imperialist. That is, part of the project of using economics to answer questions that non-economists don't think of as economics, and applying economics to understanding legal systems is one of the things that does that. But I also have historical interests, and the book that you wanted me to talk about today is a book that came out of a seminar that I taught every other year for quite a long time at Santa Clara University School of Law, on legal systems very different from ours. And it was fun. I learned from my students, and hopefully they learned from me, and eventually I made it into a book.
And just to be clear, the ours in the title is Modern American Law. Is that right?
Correct. Although from the standpoint of that book, modern American law, modern English law are essentially identical. And modern American law, modern European law, and modern Japanese law are similar enough so that I don't really count them as very different. So the closest I came to our system was 18th century English law. And that was because I had already written an article on it, and it turned out to have some very interesting features. But most of the systems I was looking at were much more different. They were things like Saga period Iceland, which I had written about a long time ago, modern Amish, Imperial China, which is a fascinating system, Periclean Athens. I'm not going to give the whole list. And I should say, to be fair, there were 2 chapters written by other people. There were 2 people I knew who had written books on interesting legal systems.
Pirates and Prisons, right?
Pirates and Prisons, right. Peter Leeson and David Scarbeck. So I got them to do what were essentially chapter-sized versions of their books. I could have done it myself because I'd read the books, but I figured it'd be better to have them do it. So really, I'm the author of almost all of the book, minus 2 chapters.
And is it true that the origin of your teaching the course was just more or less a commitment mechanism to get you off your butt to do some new research?
That's the story I like to tell, that the sequence of events was that at quite a long time ago, I got interested in the legal system of Saga period Iceland about 1,000 years ago. And that ultimately came, let me go back a little bit further. There was an exchange between 2 prominent economists at Chicago and 2 prominent legal scholars at Chicago, in which the economists were arguing that our system of criminal law is not incentive compatible. That is to say that it is not in the interest of the people in question to do the things they're supposed to do for the system to work. And my version of their story, not their version, is I'm a cop, you're a bad guy, and I've got the goods on you. I've got the evidence that will send you to prison. And from your standpoint, going to prison is the equivalent of a $100,000 fine. And from my standpoint, sending you to prison will get me a gold star in my report card and raise my lifetime income by $10,000. Well, according to Dragnet, we know what happens. I turn the evidence over to the prosecutor, you go to jail. According to economics, we know what happens. Markets exist to move resources for their highest valued use. And the evidence that you are guilty is worth $100,000 to you and $10,000 to me. So I sell it to you for some price in between those sums. And that means that in order for the system to work, you need, in effect, to have a second layer of cops watching the first layer, maybe a third layer watching the second layer. So Becker and Stigler said, well, how about we solve this problem by instead making it that we don't pay cops salary. when you pay $100,000 fine, the cop who caught you gets it. Now it's not in my interest to accept a bribe unless it's the full $100,000, in which case we just saved the trouble of a trial. So it was sort of an interesting idea, and they explored a little bit. And then Landis and Posner, who are two prominent law and econ people at Chicago, wrote a response in which they first pointed out that once you filled out the details, what Becker and Stigler had really done was to reinvent tort law. Because after all, in tort law, you wrong me, I prove it, your fine is the damage payment, which I collect. And they then raised some problems with doing that. Basically, they had what they thought was a proof that once you filled out the details, although it might work, it couldn't work perfectly. That the logic of it was such that you were trying to solve an impossible problem when you set it up in order to get it optimal in all ways. So I got interested, and I ended up writing two different articles. One of them was a theoretical article showing how you could solve the problem they had raised, showing that, in fact, by a slight tweak in how you set up the institutions, you could indeed make it, in principle, perfect in both the ways they said you couldn't. But the second article was about Saga period Iceland, because it occurred to me that I had heard about a real-world system that wasn't that far from what they described.
How did you first get turned on to Saga period Iceland?
I read the sagas. I read some sagas. The saga, for people who, assuming there might be somebody in the audience who isn't familiar with Saga period Iceland, Iceland was settled in about 870 AD. In 930 AD, they worked out a legal system, and that legal system survived for about a third of a millennium. They finally give up and turn over the country to the King of Norway in the 1260s. There were problems before that. There's about a 50-year period of breakdown before that, but that's still better than we've done, especially since our period of breakdown, namely the Civil War, happened a lot faster and was a lot bloodier than theirs. But in any case, the sagas are a literature. Let me put it this way. One of the things that ought to impress you about Saga period Iceland is that this is a population of about 70,000 people in a far corner of the world, most of 1,000 years ago. And there are probably at least a dozen books they wrote that are still in print in English translation. All right, that's the size of a small suburb. Those are the sagas. And they are, in effect, novels. They're stories. Some of them they're probably some mix of history and fiction, and we don't know for sure the details. But it turns out that a lot of what they're about is the legal system. That there's a quote I came across by, I think, a 19th century scholar who said that it was extraordinary that such an elaborate and sophisticated legal system existed among people whose chief hobby was killing each other. And he was wrong. Their chief hobby was suing each other. And they just had to have a killing once in a while to keep the lawsuits going.
I haven't read it, but it comes like a lot of the drama in the sagas is them suing each other. It's like a courtroom drama, medieval courtroom dramas.
In effect, it is. That's right. There are, in fact, substantial scenes that are happening in effect in an outdoor courtroom. And the person who Njal's saga is named after, it's one of the most famous of the sagas, is not a great warrior. He's the best lawyer in Iceland, or at least probably one of the best, maybe the best lawyer in Iceland. It was an interesting system, but it was a system where if somebody killed your relative, you sued him. That is to say, I like to refer to it as a semi-stateless society, because there was a law code, there was a court system, there was a legislature to change the law code, but there was no executive arm of government. There was no governmental mechanism to enforce the law. So I sue you, we go through a legal process. The legal process says you owe me 100 ounces of silver, and you either pay me or you don't pay me. And if you don't pay me, I have you outlawed. It is now legal for anybody who wants to kill you, and it is illegal for anybody to protect you. So it was a system in which it was in a sense less of a state system than what Becker and Stigler had suggested, because their system, the government was still enforcing the verdicts, but it was a system where the job of the police, as it were, was being taken over by private parties with no equivalent of a police force to enforce it. So that intrigued me, and so I read everything I could find. Now it turns out that there's a surviving body of legal rules, which at the time I wrote the article had not yet been translated into English. And so I worked from the sagas themselves and from secondary sources. When I got to writing this current book, some nice people had translated the collection, 2 volumes, and so I read it. And that was quite interesting.
Old Icelandic is pretty rusty, I'm guessing.
I do not know Old Icelandic, alas. But part of what was interesting, part of what I discuss in the chapter in the book, is that the Gragas, which is the collection of legal rules, is in some ways inconsistent with the sagas. And
in what ways?
Don't know. Oh, I'd have to go read the book. I go through a number of details where things are not happening in the sagas the way it is implied that they ought to have happen. I guess the clearest thing is that in Gragas, if I attack you and you kill me, I die with forfeit immunity. That because I've attacked you, sort of like a self-defense case, you do not owe damages for killing me. In the sagas, you have cases where a bunch of people attack some people, and the guy who were attacked kills some of the attackers. And there's a famous scene in Njal Saga where Gunnar, who is a great hero, and his brother, who's pretty good, are attacked by a group of enemies, and they kill some of them, and the rest run away. And his brother says, "Why don't let's chase them and kill some more of them?" And Gunnar says, "No, our purses will be empty by the time we pay for the ones we've killed already."
They couldn't afford the what is it, Weregild?
Yes.
Blood price.
Yes, and that's clearly suggesting that even though they're not at fault, what'll actually happen will be a negotiation, but there is at least a risk they probably will have to pay some damages. So that's the clearest example. But there are a variety of other things that are not consistent. So that was sort of fun to discuss. But anyway, that was how I first got interested in this general project. And I thought it was fun to try to make sense of a legal system. People then were not stupid, maybe no stupider than we are, yet it seems very strange trying to understand it. And then a good many years later, I got interested in the legal system of 18th century England, criminal law in 18th century England. And I originally got into that for the wrong reason, as it turned out, but it was a very interesting system. I originally got into that because Gary Becker, who I mentioned in the Becker and Stigler thing, also had a piece where he was raising a sort of a puzzle, the idea that suppose we're catching 20% of the criminals and putting them in jail and fining them $10,000. How about we catch 10% and fine them $20,000? That ought to have the same deterrent effect, the average one. How about 5% and 40,000? And the implication seems to be that the efficient legal system will use infinite punishments with infinitesimal probability. One of the things that the 18th century English system is famous for is what's called the Bloody Code. And that was a system of criminal law in which very nearly all serious crimes were capital. So it sounded like that was something along the lines of what Becker had suggested. You can't go to infinity, but you can hang people. So I got interested. It turned out it wasn't really true. That was one of the interesting things. It was true on paper. But in fact, if you were charged with one of those offenses, judging by the list, the sets of cases people have looked at, you had, I think, about a 1 chance in 8 of being hanged. And if you were convicted, you had maybe a 40% chance of being hanged. So the system was really set up so you could get convicted of a capital offense, and then there were various interesting ways out. But it turned out that the interesting thing about it was that it was also, in a somewhat different way from the Icelandic, a system of privately prosecuted law, that there were no police and no public prosecutors, essentially. The only crimes where the government gets involved is if you steal from the post office, if you commit a crime against the crown. But as far as ordinary crimes, it was up to the victim to find out who did it, bring the evidence to court, prove he did it. And unlike a tort system or unlike the Icelandic system, he didn't collect anything. All right. So it was privately prosecuted by the victim or somebody acting for the victim. But it was not clear what the incentives were to prosecute. And yet it was a functional system. It lasted for quite a long time. Not as long as the Icelandic, but quite a long time. So I got interested in that. So that chapter was really a bunch of different puzzles, because that system turned out to raise, 3 or 4 or 5 different interesting puzzles, which I explored. And then I was lazy for a long time. I didn't do anything interesting along those lines. And it occurred to me that this had been a lot of fun. I learned quite a lot from both of those articles, and they were good articles. And I needed some way of getting myself to stop being lazy and get some work done along those lines. So I announced that I was teaching the next year a seminar on legal systems very different from ours. Well, once I'd announced that, I had to get enough material for a semester's seminar. I then went into our library, which had nice, helpful people at the law school, and I explained what I was doing. And they ended up providing me with a rolling bookcase, I think 2 or 3 shelves, and maybe, I don't remember exactly how big, but full of books that they thought might be relevant. And I went through it, and I ended up with a reasonable number of interesting legal systems. And over the years that I taught it every other year, I also got interesting stuff from the students. Because it was a seminar, you had to write a paper, and almost all of the papers consisted of finding some legal system I hadn't covered and researching it the same way I had been doing in each of my chapters. So in effect, each paper was like doing one of my chapters.
And with the diversity of the student population, were some of them talking or elaborating on legal systems they had firsthand experience with?
I just noticed I have this lying around. This was one of the papers. I don't know if you can read it, but it's Harmony and Order in the Ancient Egyptian Legal System. Don't remember if it was a good one or not. For some reason, it happens to be sitting here. But yeah, no, I had a variety of people with different backgrounds. I guess my 2 favorite stories on that. One of them was one year, there was a tall, sort of, I would say, very Anglo-looking fellow. And at the beginning of the semester, when I was discussing the class, I said, do any of you have some special knowledge or some special background that will help you pick a society to study its legal system? And he said, well, I speak Vietnamese. Well, that seems sort of odd. And I said, you speak Vietnamese? How come you speak Vietnamese? No, I was a missionary. He was or had been a Mormon. And I said, in Vietnam? And he said, no, Los Angeles. The Mormons are smart, right? You've got an immigrant population. It's much easier to get to them than going to Vietnam, but they're still potential converts. So he wrote me a pretty good paper on the legal system of ancient Vietnam.
I thought you were going to say of the Mormon Church.
No, somebody else did that.
Did anybody ever write a paper on the internal legal system of Scientology?
No, that might be interesting, but I don't, as far as I know, I didn't have any Scientologists or ex-Scientologists in the class.
It just occurred to me reading, about Amish law and Romani law, that Scientologists also practice a form of shunning.
Yes.
That came out very, I've read a decent amount about it, and it sounds, and I've heard, former Mormons or former Jehovah's Witnesses talk about their practice of shunning, and yes. It sounds very similar.
I think there are a number of similarities actually, but because I think Scientologists also practice essentially abusing the legal system in order to punish people, that is suing in various ways and so forth.
They do. That's primarily outsiders.
But that's one of the things the Romani do.
Yeah. So, but the Romani do it to each other, right? Or at least the one from California, the group from California you wrote about.
That was the story. I think the particular one was somebody in Texas, but the author was somebody who spent time with California Romani. But in any case, so that's how the book came to be written, and it turned out to be a lot of fun. It was had all sorts of interesting stuff in it. But the last year I taught it, just before I retired, my class consisted almost entirely of Saudi LLM students, and Saudi Arabia is pretty much the closest thing to traditional Islamic law of any modern society, a modern state. Islamic societies talk about having Sharia law, but it isn't really true. And the Saudis are really about the closest. I think Sharia is the wrong term for reasons I discuss in the chapter.
Yeah, you go over that's more of kind of like an ideal conception of law in the mind of God, and
that at least is what I think is the best interpretation of it. I might be wrong, but yes.
Now, obviously, they practice it, not Sunni, but Shia is modern Iran close to an Orthodox Muslim
that's
system?
A good question, and I don't know. I actually gave a talk in Iran online maybe 2 weeks ago, and some of that came up, but I don't know enough. I'm only really talking about Sunni because that's what I've studied.
Yeah,
and it was a very interesting system, but that meant that I had primary sources in my classroom. In fact, there was one assertion about the legal system that I had gotten from what should have been a reliable secondary source. They told me wasn't true. There was a particular institution which, according to my source, had died out a long time ago. And my student said, no, it hasn't died out. The last names we're listed under are indeed labeling us by our tribe equivalent. And these were essentially the modern survivals of the pattern of Arabic tribes. And they affected the legal system, so that if you ended up having to pay a large amount of damages, some of that payment would be shared by the other members of your group. So it was a non-trivial matter. Furthermore, as far as I could tell, the marriage was almost entirely endogamous within the tribes. Lots of other interesting things. There was I think only one woman among them, and her mother was a law professor. And I had some long conversation with a nice lady, very interesting conversations.
A law professor in Saudi Arabia?
Yep. Correct. In Saudi Arabia, with I think one exception, all colleges are either men's colleges or women's colleges, and a women's college has no men in it,
including the professors and administrators.
Professors. If they have to have a lecture given by a male, it's done by closed circuit television. In Saudi Arabia, a restaurant will have an area for men, an area for women, and an area for married couples. By her account, if her brother wanted to get married, it would be the job of her and her mother to find him a bride, because there were no contexts in that society in which single men and women were expected.
Yeah, you can't mingle.
Yeah, that's right.
In a modern context, does electronics get in the way of that? I
don't know. The question didn't come up. On the other hand, it wouldn't be as hard as it would be for us, because the total number of candidates would be pretty small. There's have to be somebody of the right age, presumably about the right status, income level, and so forth, from within her tribe. So there might be only 8 or 10 women who he could marry, so to speak, or could plausibly consider marrying.
And of that group, the women in his family would make the decision.
I don't know. My guess is he would get a final, at least when I've talked a long time ago to a woman from India, from southern India, who was part of an arranged marriage. And at least in that system, the couple had a veto at the point when they were introduced to each other in some form. I don't know how they do it in Saudi Arabia, but the main search, as it were, was being done by the family. That's the case here. So anyway, it was a lot of fun. And that was the last year. And I thought it was a neat way of ending it. It gave me some additional information. So anyway, that's what that book is about. And
it's a very fun book. You mentioned something about 18th century England, the penalties, the bloody code, anything, above petty theft or whatever was the death penalty, essentially. On paper, but not in practice. The only
exception for some odd reason is manslaughter. It was a crime, but for some odd reason was not treated as a capital crime.
So that seemed to me, reading through the different chapters in the various legal systems, to be a surprisingly common pattern in Islamic law and Jewish law. The traditional punishment for a disobedient son being to be stoned to death. And you point out that doesn't just sound barbaric to modern ears. Apparently, it sounded barbaric to ancient or at least medieval Jewish ears as well.
You have Jewish scholars who assert that it has never happened.
So my question is, why is that such a common pattern all the way from 18th century England to, second millennium BC?
The obvious reason why capital punishment is much more accepted in past societies is that they're much poorer than we are. Imprisonment is expensive.
But why not flogging or ostracism or something?
Well, but most of them do use flogging. Certainly the Chinese does, the Islamic does. In fact, the Imperial China really doesn't make much use of capital punishment. There's some, but it's fairly low there. but there are going to be some cases where it's more serious than a flogging that won't kill him will punish. One of the things I discuss in the English case is the absence of galley slavery. That galleys, my view at least, and I'm not sure I'm right, people think of galley slavery as sort of from classical antiquity, from the Romans. It isn't true. Galley slavery, as far as we know, is a Renaissance invention. And I think I know why. I think what's going on is that through antiquity and most of the Middle Ages, naval warfare was basically a land battle on a ship. That you grappled the other ship, you boarded it. You can see that very clearly in the Icelandic sagas, which are describing Viking conflicts. Well, what you don't want if you're going to be fighting hand to hand is a crew that is chained, disarmed, and hates you. You want your crew to be people who will then get up with their axes and swords and go fight the other guys. So I think it's only when ships start to become gun platforms that then you don't care if your machine, if your engine
can afford to have a bunch of hostile fifth columns on your ship.
Right. So what seems to happen is that when galley slavery is invented, Mediterranean powers stop executing able-bodied men because they've finally got a form of imprisonment that pays more than it costs. Galleys apparently don't work very well in the Atlantic because the waves are too big. So the English didn't have that option. And what their equivalent was transportation, so that you are convicted of a capital crime. And if the judge does not think you really ought to hang, he offers you one. There are several alternatives he might offer you, but one of them is to agree to be pardoned on condition of transportation. And that means that you have agreed to 17 years of indentured servitude in the New World. Australia was later, but most of the period I'm looking at was before the American Revolution, when they could dump them on the colonies. And so that was a way of, and even there it was tricky that what they ended up doing was that a captain had a ship full of transportees. And when he gets to the New World, he auctions them off. I believe it was the case, if I remember correctly, that when the system started, the captains were unwilling to take anyone except sort of basically healthy young men, because what they could get for auctioning them wasn't enough to cover the costs. And I believe, if I remember correctly, I did this stuff a long time ago, so I may have details wrong, but I think it ended up that the government subsidized transportation, but not by very much. And that was enough so that to get the ship captaincy willing to take more or less everybody they were given, transport them to the New World and auction them off and come back for another load. Now there are other forms of pardoning. The other two versions of the pardon, other than transportation, were enlistment. If there was a war going on, the judge could agree to pardon you on condition if you're agreeing to enlist in the Army or Navy, because they always needed soldiers and sailors. But the judge could also just pardon you and send you home, tell you not to do it again. And so I spend some time in the chapter trying to make sense of those institutions, trying to figure out why you would have a system where you sentence people to die and then say, oh, by the way, you're not actually dying, such and such.
If you start that high with a possible death sentence, there's a lot of places below that you can go, but maybe it wouldn't be as tenable to start with a lower sentence and then say, just kidding, you're going to be executed.
That wouldn't work very well. But anyway, so again, this is stuff I discuss in some detail in the chapter. That was one of the fun chapters, one of the longer chapters, as was the Icelandic. But then I've got lots of others. And I guess probably the most, insofar as anything novel that comes out of it, because it happens to be related to my other interests, it was looking at what I referred to as feud law, of which Iceland is an example. But that there have been a noticeable number of societies where law enforcement was private and decentralized. And I discuss probably 3 societies of which that's true, and 4 if you count the Romani, of which that's true. And I then have a chapter which is trying to work out the logic of it. That is to say, if you have a system of this sort, And the basic logic of a feud system is if you wrong me, I threaten to harm you unless you compensate me. And then the question is, under what circumstances does that work? Under what circumstances does it actually give a working legal system?
And you point out that a feud system is totally unrelated to the idea of a feudal system.
Correct. The words have no connection, even in etymology. They come from entirely different root words.
They're very inconsiderate words. It's quite confusing.
Yes. But the feud system has to solve a set of problems, and I discuss in the chapter what those problems are and how the various systems I looked at solve them. But it can function. I mean, the Icelandic system functioned for a long time. The traditional Somali system, back before they tried to create a country of Somalia, seems to have worked tolerably well for a long time. The Romani have been around, we don't know how long, but at least in Europe for at least 600 years or so. Well, there are two different kinds of Romani legal systems. I discussed that, but one of them is essentially a feud system. So anyway, so that was fun. But the whole project was fun, that we're used to taking for granted the way we do things. That's a mistake, because there are lots of different ways of doing things, and people in the past were not generally stupid, no more than we are. If you sort of start out with the assumption, not that they did it this way because they were too ignorant to do it our way, but that this was a solution to the problems legal systems deal with, how did it work, what issues did it raise, and so.
So speaking of very different legal systems, one thing that's jumped out at me is the chapter on the Romani. Marriage is often considered a human universal. And your chapter at least claims that one branch of the Romani does not practice the institution of marriage, or at least if they do, it's maybe sufficiently unrecognizable. Can you say a little bit about that?
Yeah, sure. That's a somewhat special case, though, because it's only the Kale, the Finnish Romani. It's not two of the other Romani groups, but the Kale have no institution of marriage, and they, as it were, for public purposes, do not acknowledge the facts of human reproduction. What happens if a couple want to, in effect, become a couple and produce children is that they run away. They run away from the household of whoever's, probably the woman's household. They run far enough so that her pursuing relatives can't catch them. They then produce a child. And when the child is weaned, they return to the household, act as if they're guilty people who behaved very badly in wanting to do this. Her sisters smuggle her and the baby into the household. He is very apologetic and joins the household. And the child, in effect, is not, well, the child probably knows who his mother is, but certainly for official purposes, all of probably her sisters, all of the women of that age are equally treated as mother of the child.
What about the father?
I guess they could end up in the father's household, I guess. I'm not sure if they could, but the father will commonly live with them. I'm not sure to what extent they talk about as being the father. They probably don't, just given the general prejudice. They don't celebrate birthdays until they're about 40, because 40 you've sort of gotten far enough from the shameful fact of having been born. So it's interesting. There was a Finnish anthropologist who investigated all this stuff and describes it in some detail.
But once they return, the mother and father, there's no ceremony, there's no coupling ceremony, and they
might or might not stay together.
Okay. So, but it would be the norm, at least, or not unusual for them to go off, do this. They have their they stay away for a year while they're trying to get pregnant. I don't know how long.
More than a year, because the
weaning process.
The baby has to be weaned.
I'm assuming they rush that process.
By its mother. And I think generally they use long dresses, and it's not obvious the woman is pregnant, at least until she's very pregnant. Anyway, that was one of the interesting ones. But there are lots of interesting things out there. That was, again, part of the fun of doing that kind of book is all of the interesting things that are out there.
One of the interesting things you mention in the chapter on the Plains Indians is how to think about source material for these legal systems. I mean, so, for instance, Imperial China and ancient Jewish law is documented just ad nauseum.
But Imperial China is a complicated case, because when I first wrote that when I wrote the first version of that chapter, long before it was a book, my sources were Western scholars who were basing their description of the legal system on the Chinese legal literature. after that, after Mao dies and China opens up, people get access to the records of low-level courts. And it turned out that what we had thought was the legal system was really the elite view of what the legal system was supposed to be, but was not an entirely accurate description of how the legal system actually worked. So I discussed that in the chapter as well. So that was a case where this is a system that vanished more than a century ago, but nonetheless, you have ambiguity because not all of the source material was available until relatively recently. And it turned out that the elite, the stuff they wrote about the legal system was pretty clearly not representing the legal system very accurately as it actually functioned.
Is it probably that they were ignorant of it, or that it was for propaganda purposes?
Well, not exactly propaganda. Look, think about our legal system. How many people who have not looked at it carefully believe that criminals actually get a jury trial?
So it's like a kind of very rough civics class version of our legal system compared to going through and digging through all the case law.
That is the actual fact of our legal system is something well over 90% of felons are convicted without a trial because they have plea bargains. That's not the sort of the image we use. Some people know that. It's not exactly a secret. But if you think of sort of the standardized explanation of how our legal system works, it involves everybody having a right to a trial, and it implies that people actually are only convicted after having a trial, and it isn't true. So I think that the Chinese are not the only people who have a sort of an idealized version of their system, which is what the philosophers and the legal scholars write about. But going back to the Indians, one of the issues, the Plains Indians, I have access to secondary sources written by people who were talking with Indians who had been alive before they went onto reservation. So they at least had some sources from the very end of the period they were looking at, when these were essentially independent nations of their own. But then you have to look at the biases of the sources. And that for that, you have different sources saying different things. That the clearest case is the Comanche, because you get a rather attractive picture of the Comanche by people who were interviewing them at the time when they were a sort of pitiable remnant of what had in fact been a ferocious and for a long time very successful society, which went around torturing people to death and raping women and kidnapping kids. And more or less, I think they slowed the expansion across Texas by something like 20 years. And they did that in spite of the fact that their opponents, Mexican and American, had much larger populations and better weapons. But they were very good at fighting. And that's interesting. But I think that if you compare I had one of my sources was from somebody who was captured by the Comanche, I think in the 19th century, was essentially a slave of theirs for a fair while, eventually succeeded in killing his owner and escaping. And he then describes the whole thing. And that's not very much like the picture that the legal scholars who were interviewing Comanches in the 1930s probably were presenting.
And he might have the opposite bias if he was interested.
Well, I don't think so. He surely had some biases. He wanted to make a good story of it. But I think it's pretty clear that the basic factual account, the fact that they did torture captives to death for the fun of it, more or less, is real. And anyway, but that's, I mean, it's a general problem in scholarship of any sort, how you try to tease out your best guess of the truth from the sources.
Mm-hmm.
And, the sources
and none of the Plains Indians that you go over, none of them had written records or writing about their legal system, right? It's all oral records and interviews.
No, it's all oral. That is, they've got oral traditions which tell you something about it. And in the case of the Cheyenne, who are they're very interesting because they have a sort of a proto-government part of the year that the tribe gathers together in the summer and disperses through the winter for practical purposes, because in the summer they have sources of food that can feed a whole bunch of people at once. And in that case, one of the sources was a man who became friends with a bunch of the Cheyenne probably before they all went onto reservation, remained friends with them for a long time thereafter, clearly had a very positive picture of it. And so he was giving a sort of a firsthand insider picture as opposed to the more secondary sources who were, relying on this interview with this Cheyenne and so forth. So that was interesting. And,
which legal systems did you not include, but that you would have liked to?
Well, I guess the obvious one would be Roman law. And I've got a chapter on Roman law in somebody else's book, but it's a very big subject in which there's an enormous amount of scholarship. I don't really read Latin because I took Latin in high school, but I can't actually read it. And I think that's why the problem in general is that, in a sense, I couldn't really do what I was trying to do, because being thoroughly competent in one legal system is, if not quite a life job, it's more than a 6-month job, shall we say. And I tried to control for that as best I could by writing a draft of a chapter, then finding somebody who was actually an expert, getting him to look at the draft and tell me what I had wrong. And the 18th century English was probably the best one, because I, in fact, got in touch with a scholar in Canada who was probably the world's leading expert on the subject. He's no longer alive, but he was a nice fellow, and he was willing to tell me, what I had right or wrong. That was in the case of the Somali. I located the relevant scholar, who was a retired London School of Economics anthropologist, who had been studying the Somali since the 1950s or so. When I was looking for literature on the Somali, I think the first 2 books I found were him, and the third book was a festschrift in his honor by other people. And so I asked him some questions, and instead of answering the questions, he said, the answer to your questions is in such and such one of my books. And so I was able to find online that book, and sure enough, it told me the things I wanted to know. For Jewish law, I discussed it. I can't remember if I got any real scholars. I certainly had at least one Orthodox friend who I got to comment on it, but I think I did a little better than that. All of this is long enough ago, so I'm not sure I remember all of the details. But that was what I was at least trying to do where I could. The Icelandic, I think I ended up getting somebody who had been a colleague of mine at UCLA when I was originally doing my Icelandic work, and who's one of the leading scholars to look at it. But that, at least the theory, which I did to some extent, was that I used the secondary literature to get the best picture I can manage of this system. And I then, having written a draft, find somebody who actually is competent to write the chapter and have him tell me what I have wrong.
It just occurred to me that it's such a fun book. It could easily be expanded to an encyclopedia, just to have one interesting and engaging essay about the legal system of, and obviously you have 2 other authors in this book. A project that big would have to involve more people, but
alternatively, if they solve the aging problem.
I'm crossing my fingers as well. So this book, obviously this book is a lot more descriptive. Your most famous book, Machinery of Freedom, is a lot more prescriptive. How do you think these 2 books relate to each other? And did writing this book, or the scholarship in this book, change or strengthen any of your views in machinery?
Well, I concluded that when I wrote my first book, I was reinventing the wheel. That is to say, the most original part of Machinery of Freedom, the original first edition of it, was my sketch of what is stateless society with private property and trade might look like. That was the description of how a hypothetical anarcho-capitalist system would work. My inspiration for that was a science fiction novel, which was set in a very different environment and which didn't really tell me how to do it, but it persuaded me that it wasn't logically impossible to have a society where the legal structure itself was endogenous, was not being produced from the outside. And that became a project to figure out what that would be like. And after doing this work, I concluded that what I was doing was reinventing in a modern form a feud system, a feud law. And some of the features that I had are actually not all that different from some of the features of traditional Somali system, for example. Not identical, and everything is different in different ways. So that would be probably the closest link really to my work. And that didn't really change my views. In fact, I'd have to think about it. Certainly what has been true over time is that I have less and less thought that one has tidy, clean answers to questions that you know with certainty. After all, the Icelandic system broke down eventually. It took a long time, but it did. And so that raises the interesting question of, with my system, what are the potential areas of weakness? And I discussed that a bit in the first edition of Machinery. I discussed it at greater length in the third edition of Machinery, which is the current one. And that was probably affected a little bit by looking at real systems that were somewhat like that in a more primitive way. I don't think so. I mean, I think it fits together in that I was creating a legal system unlike ours, and these were a bunch of others. But
it occurs to me when you're thinking in the abstract about radically alternative legal arrangements, one thing to do is and a productive thing to do is to sit down and try to reason through what a reasonable solution would be. But another way to start is to scour the ends of the earth for if someone has already solved this problem. And you draw on medieval Iceland and Machinery. Something about the Somali system jumped out that felt, even though it's I don't know how ancient, but it's a traditional customary law system. But the idea of the dia paying group felt almost like, a primitive insurance company or something like that.
I would have said the dia paying group is a primitive version of my rights enforcement agencies.
Yeah.
Because they share the obligation to enforce the claims of their members who have been wronged. But they also share, to some extent, the obligation to pay the damage payment if one of their members has done something wrong.
That was the insurance part that occurred to me. It's got elements of both.
And that's but notice that the dia paying group is that group I was mentioning that the Saudis told me about. All right, the Saudi, what I'm calling tribes, so there's a different term for them, is very much like the dia paying group in the sense that they share the cost, not all of it, but some of it, if one of them has owes damages for something, owes dia, which is dia is actually the Arabic term for it. I call it that because the English scholars who studied Somali used that term because they'd probably studied Arabic stuff first, and therefore were familiar with dia, which is still a term. The dia in Saudi Arabia at the moment, if you run somebody down with your car, I think the dia payment is something a little over $100,000. So,
is that a unit of money? A dia, is that a unit of money?
It's originally defined in camels.
Okay.
But it got converted to an equivalent in, I think, either gold or silver, and at some point they converted it to an equivalent in whatever their money is. No, I would say probably it was more relevant not to that book, but to my work in economic analysis of law, because one of the issues that I've discussed in some detail, in part in a chapter in my book, Law's Order, is the trade-off between between basically tort law and criminal law. That if you think about it, modern legal systems are redundant because they have two different legal mechanisms for doing essentially the same work. You do something that you shouldn't do. The legal system intervenes. Something bad happens to you. Therefore, you won't do things you shouldn't do. And that could be either criminal law, where what happens is that the cops arrest you and you put you in jail, or it could be tort law, where what happens is that somebody sues you and you end up paying damages. And the fact that the division between those is not always the same. In the Icelandic, you really don't have anything. It's quite criminal law, although the fact that you can end up being outlawed and executed makes it not quite the same as tort law either, was very interesting. And I have a discussion, I think the final chapter of the book, of lessons that we could learn, ideas in past systems that you might want to imitate. So one of my standard examples that I've used for a long time is the fact that in Icelandic law, tort claims were marketable. So if I don't have enough friends and relatives to have a reasonable chance of going to court and getting you convicted without getting beaten up on the way to court, I can transfer my claim to some neighbor who's got, adult sons who went biking in their youth and relatives and allies and so forth. He can collect the money, and maybe he gives me some of it, maybe he doesn't, depending on the terms we agreed to. And I suggested that it would make a good deal of sense in our system to make claims marketable, so that right now, suppose somebody damages your car on the highway and you think you should be able to sue them for $500. You probably don't know how to get a good lawyer. You don't know whether the lawyer who's working for you is doing a good job. Well, if claims were marketable, you just auction it off to the highest bidder, and the law firm that thinks it can get the most money for it at the lowest cost buys it. You're now just a witness, and it collects.
As far as you know, have there been any somewhat modern legal systems that have had marketable tort claims?
I suspect, though I'm not sure, that there are at least some cases where you could do it in our system. I'm trying to remember, there's a term having to do with insurance claims, where I think it's something like the insurance company pays you and you transfer the claim to the subrogation, I think is the term, but it's not my field. And you transfer the claim to the insurance company, but you can't do it in general. Whereas as far as I can tell, they could. I'm trying to remember because I have some other examples, but that was sort of my favorite. I like to say that this is evidence that the American legal system is a mere 1,000 years behind the cutting edge of legal technology.
Would that be your pick if you were picking and choosing from interesting legal features of things you've read about as an interesting or potentially beneficial?
No, I think the most interesting one is private enforcement of criminal law. The most interesting one is the feud system. As something that really existed. And that's the interesting part because I invented it. I just invented it a few thousand years after somebody else did. I often find myself doing that. I discovered at one point that one of my published articles had actually been stolen by Ronald Coase about 20 years before I wrote it. That is not the whole article. The core idea of the article had been, don't know if I ever told him that. I might have.
I more meant in terms of what would be a beneficial and the somewhat practical reform in a modern legal system. What do you think would have the best would be the best recommendation of the different features of legal systems you studied?
But I think probably shifting more things away from criminal law to something like tort law. But I have a long discussion in my book, Law's Order, of the modifications you would want to make in tort law in order to make it more workable. I've got lots of discussion in Law's Order, but that's not mainly motivated by this stuff, although a little bit of it is.
You talk in Law's Order about, and you mention it in this book too, that one possible reason for the distinction between criminal and tort law, where criminal law has a very high standard of proof beyond a reasonable doubt, and tort law's preponderance of the evidence, is that, the payment of damages, even if it's wrong, is not a net loss to society. My loss is your gain if I'm paying you damages, but if I'm paying with my life or in time served in jail, that's just a net loss if it's wrong. Is there any evidence that rationale played a role in that distinction, or is that just a happy coincidence?
I certainly don't have evidence of how I did it. Somebody might. But yeah, no, that's near the beginning of the book when I'm trying to explain why economics is relevant to law. But I actually have a long series in the chapter on criminal versus tort, where I'm really asking the question, could you entirely replace criminal law with tort law? And part of the fun of that discussion is that I'm not only trying to look at that question, I'm trying to demonstrate the fact that these issues are complicated enough so that the fact you've heard a good argument for something is not an adequate reason to believe it. So I run through maybe four rounds or 5 rounds of, here is how you do it. Here is why that wouldn't work. Here is how you modify it so that it would work. Here is why that wouldn't work, and so forth. And it's fun. And I think I end up with the conclusion that there is at most a fairly small subset of cases for which it wouldn't be practical to do it that way if you modified it accordingly. But as I say, part of the reason for that is because people are too willing to say, well, look, I've seen a good argument for such and such, it must be true. And here I've got good arguments for both sides going back and forth.
That's definitely a humbling experience. If you read enough, you can or talk to enough people, you can always find very compelling arguments. Do you have any inside knowledge about your son, Patry? I know is involved in the Prospera ZEDE. I don't know if it's pronounced Zed or Zeta in Honduras.
Not really. That is, I know this has been a project he's been involved in for a long time. And I don't know how long ago it was, but 5 or 6 years ago that he started his investment fund. And I gather it's doing all right. But I see him. He's only about half an hour from here. And I have grandchildren who I like to see. Not so much during COVID, but hopefully that's getting over at this point, it looks like.
Crossing my fingers.
Well, I'm supposed to be giving a talk in Prague in April. And when the pandemic started, I was on a speaking trip in Europe. And my younger son, Patri's half brother, persuaded me by email that this one was serious. And so I canceled the last 2 talks and flew home. And in fact, at least one of them I wouldn't have been able to make ex post. It was a talk in Prague, and I think they closed the border like a day before I was supposed to arrive, by which time I was already back home.
Oh, wow.
And at this point, I've agreed to give a talk in Prague for European Students for Liberty sometime in April. I assume that if there's another wave before that, I will tell them, well, I can do it online, but I can't do it in real space. But my guess is there won't be. And I think it's pretty clear that Omicron is going to be effectively over in a month. At least I've been monitoring it fairly carefully. The peak, the current figure is about a factor of 10 down from its peak for the infection rate. And that's over a little over a month. Another factor of 10, and it's basically gone as it's back down to sort of base level. So I figure that by sometime in March, if nothing changes, it will be safe to travel to Europe and give talks and run around. So I haven't yet. I'm planning to put up a blog post and maybe a Facebook post asking whether people want me to give talks. And I haven't done that yet, but I've been watching, and I will probably do it pretty soon. And basically, my trips are normally 2 weeks, so I basically can say I'm going to be in Prague on the following day. I'm interested in possible invitations either within 2 weeks before or after, and then we'll figure out how I put them together into a series of talks.
Well, I hope you get to plug some in. Are you working on anything? I know you're working on something with your putting together old blog posts. Do you want to say something about your current projects?
Yeah, sure. A few years ago, I decided, after I'd written the legal systems book, I concluded that I didn't really have a set of new ideas that were worth writing a book about. And I did have sequels to 2 of my novels that I had ideas for, but they haven't really caught fire. So they may or may not ever get written. But it then occurred to me that I had 14 years of old ideas on my blog. So I went through, I think the total number of posts was well over 1,000, as I remember. I looked at it at some point. So I went through all of my old posts, sorted them by topic, first broadly and then more finely. So one topic is economics, one topic is climate, one topic is libertarianism, one is education, one is religion. I don't remember all of them, but those are more or less the major ones. And then what I'm doing for each one is I'm not just making it out of the blog post, but I'm making out mostly out of the ideas in the blog posts. So I find a group of posts that were really on the same subject and try to take the ideas from those and rewrite them into a chapter on that
something
subject.
So that they fit together more coherently as a book.
I also do additional work. For example, the 6th IPCC report didn't exist when I pretty much finished the blog in question. I mean, I still post a little bit, but not very much. So one of the things I've done is to go over that and to see what that does or doesn't tell us about climate issues. And similarly, I got into a debate with a Austrian libertarian economist, Austrian in the academic sense, not the national sense.
Yes.
Walter Block is a nice fellow. And we had a online debate on Austrian versus Chicago School economics.
Yeah,
and
I just watched that.
In the course of preparing that, I got interested in trying to actually understand what Austrian economics was. And I concluded that the particular version that Walter was defending, I'd asked him what version of Austrian economics he was defending, and he pointed me at a treatise by Murray Rothbard. And I concluded that version was terrible, that it was internally inconsistent. That the things he thought he had proved, he hadn't proved, and so forth. But then but it's clear that not all Austrians agreed with Rothbard. And I'm still not satisfied that I really have a clear idea of whether there are fundamental differences between, I really think of it not as Chicago, but as Marshallian economics, which Chicago is a subset. But you really do have, as it were, two intellectual traditions, one of them starting with Jevons through Marshall, and one of them with Menger and people along those lines, ending up with Mises, basically. And Ludwig von Mises, who was Rothbard's teacher and who was, I think, the closest thing to a sort of authority figure, as it were, for modern Austrians, back in the 1930s, he wrote that he didn't think there were fundamental differences. He was putting it in terms of three different schools, the third one being Valrat, who was doing French sort of general equilibrium theory, a highly mathematical nature. And at that point, Mises thought that basically, we're doing our stuff in slightly different ways, we're putting it in different words, but basically it's all the same. And he might be right. But certainly most modern Austrians don't think so. And I am not sure what the right answer to that question is. But
have
what
you
I've
looked
been
much
doing,
into the work of Israel Kirzner?
Not enough. That is, he's certainly one of the people who is not a Rothbardian, but I don't think I've read anything specifically by him. I think I've read things about his views. But I should say that what I've been doing in writing this, I don't know if this is going to be one book or several books at this point, because there's a whole lot of material. So what I've been doing is each time I finish drafts for one section. I finish writing all the chapters on libertarianism I feel like writing. I then web it. And at this point, libertarianism is up, economics is up, education is up, religion is up. I'm currently working on climate, and it'll probably be maybe a couple of months before I finish that, because I did a lot of posts on climate. It's an interesting and somewhat complicated issue. So it isn't just the blog posts, that in each of these things, I'm doing additional research and trying to understand things and so forth. But the sort of the framework, it's starting out with the blog posts and then expanding from those where it seems worth doing. For example, I didn't have any blog posts at all on Austrian versus Marshallian economics, but I'll have a chapter on that.
I'm going to push you on something I've mentioned before. So I've been to Slate Star Codex meetups at your house before.
Yes.
And I mentioned this in passing, that something I used to quite enjoy, because I followed your career for a long time, or as long as a young man like myself can. And I used to really enjoy reading your old Usenet and various Google group debates.
Yes.
And I think there's a lot of material there too.
Usenet. Usenet may have turned into Google Groups.
I think that's what it was. I was searching through there, but in particular, and he's famous now, so it might have some interest. You used to debate a lot with the founder of Wikipedia, Jimmy Wales.
Yes.
And they were great.
Jimbo Wales.
Jimbo Wales back then
was what he was called.
I remember when it occurred to me that they might be the same person, and I was very pleasantly surprised.
That was on Humanities Philosophy Objectivism.
I recall.
Which was an interesting place to argue with people. I am not an objectivist. I am an admirer of Ayn Rand. I think she was a brilliant, courageous, original woman. I also think she was wrong about some very important things. So I had a lot of fun arguing with her more. There was a range of people there, but most of them were at least objectivists, more or less orthodox. And I think that Wales was probably the best of them, that he was almost the only one who, as far as I can tell, actually tried to understand my version of anarchy and tried to rebut it. And he came up with a criticism which was not quite right, but was related to one of the real problems that I think existed in the system. So in that sense, I credit him with being, but there were some other people. There was at least one person, I don't even remember his name, but who, what I liked about it was that he was willing to reject the orthodox position when he didn't think it was right, and to take a pretty heterodox view of, I don't remember what the issues were, but some of the fairly fundamental issues. But no, I mean, there were a few arguments that got in there. Some of that stuff ended up in the third edition of Machinery. I've got a chapter on Ayn Rand, on why I think she was wrong about important philosophical issues. But it was a lot of fun. Not all of my arguing was in HPO. That was certainly a large part of it. But I remember I argued with David Graeber, who became fairly well known later, different contexts.
Well, there was a lot
amusing.
of great material there, and some of that could provide fodder for this project as well. Obviously, that's another chunk of work.
It could. And if I actually finish this project, it would be worth at least thinking about, especially if I finish it and decide that 2/3 of it will make a book. It might be fun to go back to the Usenet, assuming I can find the stuff. And I don't know how accessible nowadays it is. I think it's less accessible than it was then, since Google is theoretically in charge of it. I don't think they've done as good a job of making it findable as the earlier interface did. Yeah, and then I've also thought about experiments, about arguments on Slate Star Codex, to what extent, because I've done a lot of writing there too.
Yeah. I feel like that's replaced a lot of your blogging.
Yeah, no, it did. It quite literally did, because it was a place where there were more interesting people who'd be talking with me. And that is the neat thing about Slate Star Codex, as I've said many times, is that you had a body of people who ranged politically from communist to anarcho-capitalist, religiously from believing Catholic to atheist, and professionally from a literal rocket scientist to a literal plumber. And they were talking with each other, and it was almost all civil conversation. And that's the only place I think I've encountered online where that was true. To some extent, it's true of the two successor online things to Slate Star Codex, but less so. And that was a lot of fun. And so you could have interesting arguments with interesting people. And so I blogged a lot less after I discovered SSC. That's certainly true. Still blogged a little, but not as much. So no, I could imagine if I really decided that I had to write more stuff after I finished this enormous project, it was going to be several more years, I think, that I could imagine going to either my Usenet files or my Slate Star Codex comments, which are available, probably even findable, and seeing whether I could get out of them some interesting bits.
It first occurred to me when I read Benjamin Tucker's Instead of a Book, which a lot of it takes the form of reprinting old debates in the journal Liberty. And it's really fun and, fast paced. It's an action packed experience to read smart people going back and forth at each other. And obviously not all the debates end up looking like that, because not everyone online is reasonable, but some of them were really enriching and exciting at the same time.
I find that arguments are a good mechanism for making me learn things and think about things. So that, for example, the latest bit of my interaction with the Austrians is that one of the issues that came up basically after I had the debate with Walter, I arranged with him and a few other Austrians to sort of continue it by email. And that faded after a while, but I think we made some progress. But one of the issues that arose was the question of whether you should think of utility as ordinal or cardinal. Is utility only an ordering? Is all you can see, I prefer A to B to C? Or does it make sense to say, I prefer A to B by a lot and B to C by a little? Statements of that sort. Do you want to think of utility as only an ordering of things, or is the sort of thing you can imagine the utility of this is 17 and the utility of that is 23? And so Robert Murphy, who's, I think, again, a nice guy, probably one of the better of the people I was arguing with, put up a piece on a Mises Institute publication arguing for ordinal utility. And I thought there were a bunch of things wrong with it. And so I wrote up my term of the sequence, because he was responding to arguments that I had made in the email conversation. I think I argued with a bit, and then I asked him if I put up a rebuttal and he thought that in fact I'd shown that his arguments were wrong, whether he would be willing to say so in public and whether the Mises Institute would publish it. And what he proposed doing, and what we're now doing, is that I wrote my rebuttal, I put it up on my blog, and he is going to write a response to it with a link to my blog post. Perfectly respectable way of doing this. Anybody who wants can see my arguments as well as his arguments. And at this point, I put up my piece on the blog a day or two ago. I actually added it to Facebook and got a bunch more response from that. And yesterday, we'll see what happens. But the interesting bit is that my views changed. That I would have said before that both the cardinal and the ordinal view of utility work, and the only real argument for cardinal utility is von Neumann's argument that cardinal utility makes a rather neat way of modeling choices under uncertainty. This is the von Neumann-Morgenstern, really von Neumann utility, in which the way you imagine people making decisions under uncertainty is that they look at the expected value of utility for a gamble and then choose the gamble with the highest expected value. And that's turned out to be a very clever and interesting idea. But I concluded in the course of writing of rebutting Robert that actually I thought I preferred cardinal utility in general, that I thought there were two different reasons, one of which ought to appeal to the Austrians, why cardinal utility was better. And the first reason was that it better fits our direct experience of the inside of our own heads, that we don't, in fact, observe that all I can say about my preferences is I like chocolate ice cream better than ice cream, better than vanilla ice cream, and I like not having my house burned down better than having my house burned down. Saying that's all I can say is obvious nonsense, because I want my house not to burn down a whole lot more than I want to have my preferred flavor of ice cream. So that means that just saying utility is ordinal is dumping a bunch of information we have by introspection. Second and related reason is that if you think about it, the cardinal utility way of doing economics is a good deal easier to intuit and understand than the ordinal way. I should say this predates the Austrian issue. An economist called Hicks in the 1930s wrote I think first papers, but eventually a book, in which what he demonstrated was that everything that was being done at the time using cardinal utility could be done using ordinal utility. And that's where things like indifference curves, if you've taken an econ course, come out of. And it's true. It wasn't true 10 years later, because once von Neumann published, there was then something that cardinal utility could do that ordinal utility couldn't, namely, but that wasn't true when Hicks wrote. But I concluded that, in fact, it was a step backwards. He mostly persuaded people. That is, at this point, I think probably most Marshallian economists, as well as the Austrians, would say that utility is really ordinal, unless they're actually talking about the von Neumann case of decisions under uncertainty. And we just use cardinal things as a simple way of representing it, but that doesn't really matter. But I think they're wrong. And I think that in particular, if you think about the concept of declining marginal utility, it is very clear what that means conceptually. If you were saying, yes, I value the second gallon of water less than the first, the third less than the second, and so forth. And if you go a little further, you say, furthermore, if I get additional money, I will spend my first $10,000 on the most important things, then the next 1,000 on slightly less important, and so on. That's a nice, plausible argument. And it's a whole lot easier to intuit that in terms of the utility per unit. The marginal utility is going down as the quantity, whether it's all goods for money or individual goods, goes up. It turns out it's not rigorously true. There are cases where marginal utility rises. My standard example is the fourth wheel for your car. Fourth tire for your car is worth more than the third to you.
Yes.
But it's usually true, and it makes sense. But if you turn that into ordinal, it turns out, at least in the Marshallian version, by the time you've made it ordinal, it's a statement about the shape of indifference curves. And it's something which is much harder to intuitively understand, even though it says the same thing. One of the things that both I and Austrians, I think, agree on is that modern economics is too mathematical, that people make too much use of math instead of trying to actually understand the economics of things. Well, one of the reasons, I think, is that when you shift from doing things in a way that people can intuit pretty easily to doing things in a more or less equivalent way that they can't, they end up using the math as a crutch instead of seeing the logic and the pattern in their heads. So that's my second reason for thinking that cardinal utility is actually a better way of doing economics than ordinal utility.
Is the Austrian claim that utility is not cardinal just that it's metaphysically impossible to measure the cardinality, or that it actually isn't?
No, the claim is that it is not. Robert's claim is that it doesn't mean anything to say that my preference for ice cream A over ice cream B is greater than my preference for ice cream B over ice cream C.
I'm
It's
trying
not
to
just
understand
saying you
how
can't
it could
measure
even be ordinal. Like, what is it? Can you think of an example of an analogy of something else a little bit more concrete that is clearly ordinal but not cardinal in a way that seems counterintuitive like that? Because you're right, intuitively it feels so wrong to say that you couldn't say that anything more than I want my house to burn down less.
Well, if you look on my blog, you will find my essay, and I have a link there to Robert's essay. So you can see what he said and you can see my response. And if you wait another week or two, I don't know how long it'll take, he will presumably put up his rebuttal. And of course, what he ought to be saying is, sorry, I was wrong. But I don't expect him to say that you very rarely convince people that fast. And my real objective from the standpoint of the person I'm arguing with is not to have him say I was wrong now, but to give him the ideas such that a year from now, he will say I was wrong, or maybe we'll say, oh, no, I never really believed that at all. And one of my father's lines that I like is that the purpose of an argument is not to convince your opponent. It's to give him the ideas with which he might later convince himself.
That's very wise. So I'm gonna say one more thing about utility before I let you go, because I'm pushing you for time here. The fact of utility being ordinal rather than cardinal, that's what gives Austrians the claim that that interpersonal comparisons of utility are meaningless.
That's what Robert claims, but he's wrong. Because
I'm not saying it's true, but is that their logic, that because it's ordinal, you can't do interpersonal comparisons?
One of the things he said was that. But I don't think it's true in the following sense. First, the Austrians believe that preference is only revealed by choice. And if preference is only revealed by choice, then with either cardinal or ordinal utility, you don't have preferences, you don't have an ordering for multiple people, right? There is no chooser
no action
in the society.
Yeah.
From that standpoint, they could believe in cardinal utility and still say that it's not interpersonally comparable, cardinal utility. After all, von Neumann utility is only defined up to basically positive linear transformations. That if you turn all utilities into twice the previous number, they describe exactly the same behavior. If you turn all of them into twice the previous number plus 10, they describe the behavior. But you can't make transformations other than that kind of transformation. So it doesn't require the claim that it's interpersonally comparable. Furthermore, if you don't have the requirement of revealed preference, if you just say, can you have interpersonally comparable ordinal utility? Sure, you could have an ordinal ranking, which was a ranking over everybody, right? My ordinal ranking says I prefer A to B. Well, somebody who believes in social welfare or something could say, all right, I got an ordinal ranking too. And your getting that is preferred to my getting this. So it's not really, I don't think it's really an ordinal versus cardinal issue at all, which is a separate point. But anyway, I don't think I understand fundamental Austrian. I think I understand Rothbard well enough to say that some of the arguments he was making were nonsense. But I don't think I understand the nature of Austrian economics well enough. I mean, I can say at least one argument that Mises made was obviously wrong, but everybody makes mistakes. And he's not here, so I can't present it to him and see if he got a rebuttal. And I do. I should say I've got one of the things in my economics section, which is webbed, is my draft of a rebuttal to basically, mostly it's a rebuttal to Rothbard, and then at the end, some attempt to make sense of Austrian economics more generally.
Before we go, can you tell people how they can find you if they want to see what you're up to?
My webpage is daviddfriedman.com. It has links to most of my published articles, full text of some but not all of my books. It also has a link to my blog, which I still post stuff on, although not as much as I once did, which is called Ideas, because the basic function of the blog is for me to be able to write out whatever I happen to feel like writing about, which I enjoyed. Physically, I'm in San Jose, California. You were mentioning the meetups. Basically, Slate Star Codex was a blog that I spent a lot of time on. Very interesting. Unfortunately, it vanished, although it's got some somewhat inferior replacements at this point. And it had enough people interested so that people in various parts of the world occasionally have meetups where readers of the blog get together with each other. And before COVID, I was hosting a meetup at my house in the South Bay about every 2 months, I think. Once COVID is over, I intend to go back to that. So if you're in the Bay Area, keep an eye out and you will see somewhere or hear that I'm doing it again. I'll probably put it up on my blog, maybe on my webpage. You can come over.
I certainly will. Yeah, I'm pretty close to you. All right. Well, thank you so much for coming on. It's been a pleasure talking with you.
Thank you. It was fun. Bye-bye.
That was David Friedman, and the book is Legal Systems Very Different from Ours. I strongly recommend it. It's a book with very high returns in terms of the depth and breadth of knowledge you'll gain from reading it, so please check it out. You can find links to that book, as well as to many other things discussed in the interview in the show notes section. If you're enjoying the show, please hit follow on Apple Podcasts or Spotify, and please rate and review. It really helps to get the word out and to promote the show. I'm Chris Kaufman. Thanks for listening.